All right, we ready? I'm waiting for the thumbs up that we're ready. All right, everybody, let's go ahead and get started. Hey, everyone, my name is Ashley Jones. I'm the Managing Director of Community Programs here at the Venture Center, and we have an awesome workshop for you today. Here with us are Jane, Kim, and Daveante Jones, two labor and employment attorneys with Wright Lindsey Jennings. They're going to talk today about some legal implications for returning to the workplace during the pandemic, including calling employees back from layoff or furlough, unemployment compensation, employees working reduced hours, business travel, and several other topics. They're also happy to answer your questions as well, and so we'll save room at the end for that. But first, a big thank you to our sponsors of all of our community programs, Wright Lindsey Jennings, Frost, and the Little Rock Chamber for their continued support in everything that we do. So whether you're tuning in virtually and on Zoom or Facebook, we're excited to have you with us today. And I will go ahead and turn it over to Jane and Daveante.
Thank you so much. Well, as you all know, many restrictions that were put into place as part of the response to the COVID-19 pandemic have been lifted or are expected to be lifted soon. And while the idea of returning to regular work may be a welcome move or appealing for businesses that have struggled and survived through all this disruption and chaos created by this unprecedented situation, I think it's also fair to say that it's, returning to work during a pandemic is a little bit of a daunting task, given that it'll be a first, at least for most US-based employers. And the fact that return to work can potentially be dangerous if mishandled, that presents another unique issue and another kind of complicating layer to the whole situation. Hang on just a second, let me get this up. All right, so with that background, it's not surprising that our labor and employment team at Wright Lindsey Jennings has received many return to work related questions from clients. And based on the most common questions that we've received, we'll cover today some of the key employment law issues and challenges to consider during the return to work process. We generally view this process as a two-step process, as you can see on this today, the agenda slide that we start with planning for your employees' return, and then protecting your employees and business post-return. So let's turn to our first question relating to planning for your employees' return to work. What legal implications should be considered when bringing back furloughed and or laid off employees? So first and foremost, as with any other employment related decision, callback decisions should be based on objective factors and consistently applied. And by objective factors, we're talking about, tenure or maybe disciplinary type of record, disciplinary action records, and then, or also, of course, business need. I know, like for instance, when restaurants were reopening, obviously they at first when businesses or restaurants were initially closed, dine-in was closed, the many service staff was laid off. And so, of course, that made sense when you're calling back those employees, it was going to be a lot of service staff, because kitchen staff, at least some restaurants, had maintained kitchen staff in the restaurant for takeout and curbside delivery. these objective factors is particularly important if you're bringing employees back in phases, like many employers are doing, and you can help avoid claims of illegal discrimination and retaliation by documenting your selection process or criteria, and ensuring that all decisions are made for reasons that are not based on a protected class, such as disability, gender, age, or for instance, all employees who are on FMLA leave or some kind of unpaid leave under the ADA. And whether you require returning employees to go through the company's normal hiring process may depend on whether the employees were furloughed or laid off. So for instance, typically furloughed employees are placed on an extended unpaid leave of absence. So they'd still be on your payroll, and there'd be no need to put them through the company's normal hiring process. You just place them back in their prior position with the same pay rate and then document their return to work date. On the other hand, laid off employees have usually been terminated, so they'd no longer be on your payroll. And in that case, they'd go through the company's normal hiring process, even if you skip a formal interview, and those employees should complete all new hire paperwork, including employee handbook and other policy procedure acknowledgements.
A big issue that we've seen with a lot of our clients is just getting their employees back to work. Because one thing you have to consider is just because society is opening back up does not mean COVID-19 is going away. And we're going to make sure you remember that, because we're probably going to repeat that line about 15 times throughout this presentation. But some employees are just fearful in general of going back to work, maybe contracting COVID-19. They're trying to be safe with themselves, safe with their family members. And not only that, fear that employers are kind of competing with, they're also competing with expanded unemployment benefits. I'm sure everybody knows by now about the CARES Act, which among other things, expanded upon the state unemployment benefit system that was already in place. So under the CARES Act, there's employees are now able to get $600 extra dollars a week in benefits through the end of July, as well as the CARES Act adds an additional 13 weeks to the already 26 weeks worth of benefits that an employee is eligible for during the year. And so employers are having to deal with both of those things. But the question was generally, can an employer force an employee to return to work? And in general, it's no. But if just fear alone of catching COVID-19 is not enough for an employee to refuse an offer to return to work and still be qualified for unemployment benefits. And I'll kind of expand on that in the next slide, which addresses a question that we've also gotten a lot, is if furloughed or laid off employees receiving unemployment benefits refuse to return to work, what should employers do? The biggest thing, like I was saying, if it's not a valid reason related to COVID-19, then an employee can't just refuse an offer to return to work. One of the requirements to be eligible for unemployment benefits is to be available to work. And if they are refusing an offer to return to work without a valid reason related to COVID-19, that means they're unavailable to work, which would disqualify them from unemployment. That's seen also here in this quote by the U.S. Department of Labor. They came out in some of their guidance, barring unusual circumstances, a request that a furloughed employee return to his or her job very likely constitutes an offer of suitable employment that the employee must accept. And if you come across a situation where your employee, where you've offered your employee an offer to return, the chance to return to work, and they refuse, you update the Division of Workforce Services that they've refused that offer. and give the reason why they're refusing. And like I said before, if it's not a valid reason related to COVID-19, it will likely disqualify that employee from drawing unemployment benefits. And so, but the good news is this is both enticing to both the employer and the employee. The question is, if furloughed or laid off employees are recalled on a reduced schedule, can they still receive unemployment benefits? And the answer to this is yes. And like I was saying, it's both enticing to the employer and the employee, because some employers may be opening up in phases. So they may be recalling employees on a reduced schedule. The employees may be receiving reduced wages. And with that, as long as the employee is working less than full time, which is 40 hours, and their wages are less than 140% of the employee's weekly benefit amount, then they still be eligible for not only the state unemployment benefits that they would normally receive, but also the extra $600 under the CARES Act. And so when I say weekly benefit amount, that is the amount that the employee would draw weekly from the Division of Workforce Services. And nobody really knows the formula to figure it out except for the Division of Workforce Services. And an employee wouldn't really know the exact weekly benefit amount that they will receive until they've applied and been approved. But just to kind of give a framework, an employee can make anywhere from $81 a week minimum to a maximum of $451 a week. And that is, and then as long as you were receiving some type of benefit from the state, then you would receive the extra $600. And so anytime that employee works 40 or more hours, or if the earnings they made that week exceed 140% of the employee of their weekly benefit amount, that they wouldn't be eligible for unemployment for that particular week. Something that employers could also keep in mind for the employees that they have not furloughed or laid off yet is the Division of Workforce Services Shared Work Program. This is a program that takes some planning on the front end, because it has to be approved by the Division of Workforce Services. And what the program provides is it provides the employer an opportunity to kind of identify a group of employees and kind of divvy up the work between them so that the employees are still working part-time and they're able to draw unemployment benefits. And so what the employer has to do is make out a list of the employees who will be covered under the Shared Work Program, submit that to the Division of Workforce Services for them to approve. And if it's approved, then the employees would go and make their individual claims to the Division of Workforce Services for unemployment benefits.
All right. Well, first, let me apologize for my poor presentation operation skills. I apparently need to learn how to multitask better, but I will try to be better for the rest of the presentation. All right. So, how should employers notify employees of return to work or rehire offers? To avoid having to chase down employees individually and having to decide, how many attempts are enough in terms of making offers to return to work, we've been recommending that clients use return to work or rehire forms. In general, those forms would include details regarding the location, start date, position, pay rate, an option to accept or decline the offer to return to work, multiple options for submitting the completed form, hand delivery, email, even if you want to say that, it's okay for the employee to take a photo of the document, the completed form, and to text it to HR, and then also provide a response deadline, of course, along with the message that says, if we have not heard from you by such and such date, we will assume you're turning down the offer and offer the position to someone else. This puts the ball in the employee's court, and you have documentation of your attempts to make an offer to return to work. That can also be helpful for the Department of Workforce Services. purposes, as Daveante just explained. All right, so should employers implement and enforce social distancing protocols in the workplace? The most important thing here to remember is that the easing of work and travel restrictions does not mean that COVID-19 has disappeared. If you've been keeping up with the governor's briefings over the past couple weeks, you know that the number of positive cases in Arkansas has been increasing. So as an employer, you have a responsibility to keep your employees safe and healthy while they're in the workplace. There have already been at least a couple wrongful death lawsuits filed against employers by the states of employees who have died of COVID-19 related complications, alleging that the employee contracted the virus at work and claiming that the employer somehow did not keep the employee safe and is negligent for failing to protect the employee at work. Claims along those lines, of course, are the worst case scenario, but given that most pre-COVID-19 working environments are not suited for this new normal that we're living in, employers will have to be careful and be sure to comply with the various current and future federal regulations and guidelines, as well as state and local directives. And I say future because much of this is because this is so new and for everyone, I think, and all agencies, the federal and state agencies are updating their guidance on a regular basis. So it's also important to keep up and make sure that you are following the most current guidelines. And most of these guidelines and directives include some type of social distancing and employee gathering restrictions. The Arkansas Department of Health has industry-specific directives, so posted on their website. And these guidelines, these directives generally include recommendations to limit the number of employees at the workplace by maintaining remote working to the extent possible. Realistically, there is a chance of a shutdown and or stricter restrictions being re-implemented. So at least for a brief period of time, having fewer employees in the workplace during that period will not only be safer for your employees, but and customers, depending on your business, but it'll be less costly and disruptive to your company if and when those adjustments have to be made. You can also limit the number of employees by allowing flexible work hours, because it's understandable some industries, some businesses, remote working is just not feasible. But allowing flexible work hours so that your employees' shifts are staggered, that can help limit the number of employees in the workplace. And if applicable, continuing to or implementing curbside pickup or delivery is also one of the recommendations set forth by the federal and state agencies. Also, employers should be proactive in assessing and reconfiguring the physical setup of workspaces to increase space between employees in their seating or working areas, and of course between employees and customers if you have customers coming into your business. If physical space is limited, employers also have the option of providing partitions or limiting employees' movement to certain zones, which can be delineated by floors or certain sections of a floor. Employers can also limit in-person meetings among employees and with customers by continuing to use virtual meeting software and providing services via remote delivery like phone or web or video. And most of the federal and state regulations either require or strongly encourage the use of face masks, especially when maintaining a physical distance of 6 feet is not physically possible.
Some of the additional return to work preparations that employers can consider, or like Jane stated earlier, there's been a lot of state regulations that have come out during this time. Just a couple weeks ago, I think it may have been when the state was kind of starting phase 1 of reopening, that the Arkansas Department of Health came out with a directive that kind of provided some things that employers and businesses are required to do, and some suggestions of things that they should do. The first thing is some signage that employers and businesses are required to kind of post outside of their businesses. One is directed at anybody who may be experiencing COVID-19 symptoms or have been exposed to someone who has tested positive for COVID-19 within the past 2 weeks. And basically that sign has to say that if you've experienced COVID-19 symptoms within the past 2 weeks or been exposed to somebody who has COVID-19 within the past 2 weeks, then you cannot enter the premises of the business. The second piece of signage is directed at the high-risk population. So somebody who may have an underlying health condition that may increase the risk of complications from COVID-19, or who may be in that age range of 65 years or older. And that sign is basically to warn the people in that high-risk population that they do not have to enter the business. And the second thing that employers are required to do under that directive is that anytime an employee tests positive for COVID-19, they have to report that to the Arkansas Department of Health. And the second thing that I'll talk about is contact tracing, which is basically which is more of a suggestion than a requirement, but it's very critical, especially when you do have an employee who tests positive for COVID-19. And so the state of Arkansas is doing contact tracing, but they've also suggested that employers and businesses do contact tracing on their own to kind of help out with the state's contact tracing. And I think it's very critical for employers and businesses to do contact tracing, because one thing that everybody wants to avoid is opening up and then having to close down because you've had an outbreak of COVID-19 in the workplace or your business. And so you may want to consider just manually maintaining a log with dates and times of persons entering the facility to facilitate contact tracing in the event an outbreak occurs. If you want to do it in a more technologically advanced way, there have been apps that have come out with contact tracing. I think some companies are even have wristbands that do contact tracing as well. If you do it that way, one thing that you do have to keep in mind is privacy concerns. While you may be able to contact trace while somebody's in the workplace, you may want to caution yourself from contact tracing your employees outside of the workplace, because that could implicate some privacy concerns there. One industry in particular that's been highlighted by the governor in his daily press conferences has been the poultry industry. Tyson in particular, they test every employee and applicant, and they're also just doing their own contact tracing as well to make sure that there's no outbreaks in the workplace. And then just some minor things, but can be very critical to helping avoid the spread of COVID-19 in the workplace. Increasing your stock of hand sanitizer, cleaning chemicals, masks, and other protective equipment, and kind of adjusting your common areas into more social distancing friendly areas. So maybe take out some of the tables, and if you have a cafeteria or something like that, if you have places where you use shared cups and utensils, you may want to think about just buying disposable cups and utensils for the time being until it's, I guess, safer to use shared cups and utensils. And I think that's about it for this slide.
All right, so sorry, I lied. I have not gotten better. All right, here we go. Should employers ask employees about COVID-19 symptoms, take temperatures, or perform other screening measures? As Daveante just mentioned, many employers already are doing this, and per the Arkansas Department of Health directive, employees should be screened for fever, cough, shortness of breath, sore throat, or loss of taste or smell as they are entering the building at the beginning of work. OSHA has received thousands of complaints from employees in connection with COVID-19 and workplace safety since the pandemic situation has started. And most of these complaints relate to having to work in close proximity to other workers, the lack of or inadequate PPE, and lack of soap or other hygiene products. And these complaints will very likely result in increased scrutiny from and inspections by OSHA as employees start returning to work. So you've got, state directives that you're going to have to comply with, but also federal guidelines again that employers will have to be aware of. From OSHA's perspective, the workplace safety complaints prompted the agency to recommend that employers develop and implement a safety policy as part of their return to work preparations. Having this type of policy in place should help ease your employees' heightened anxiety, which may be certain to depend on to what degree, but understandably, many employees will be who are returning to work will have some anxiety over their health and safety concerns. But also, a safety policy can help employers from a liability standpoint. And in general, the safety policy should incorporate OSHA, CDC, EEOC, and state local requirements and guidelines, and should cover employee self-monitoring and reporting. Basically, you want to set forth the expectation that employees must not come to work if they feel sick, and that they must immediately report if they have COVID-19 symptoms. And also, safety policy should cover employee screening and PPE in terms of describing your procedure and PPE requirements. For instance, are you going to if you require employees to wear a mask while at work, which an employer can do, put it in the policy so your employees understand what's expected of them, and so you guys are on the same page about the expectations that for the heightened safety procedures that you as an employer are implementing. Also, and also include, of course, if you're going to be taking employees' temperatures, include the procedure that you'll be implementing to take employees' temperatures. One thing that's worth noting on this is that the CDC guidelines on employee screening actually say that the screener, the person who's let's say you've got a manager or HR person taking employees' temperatures and asking all the screening questions, the CDC recommends that the screener be in full PPE gear with a face mask, gloves. It almost looks like they're kind of in a hazmat suit in the CDC recommendations. But one suggestion, one tip that the CDC gives is that you can do social distanced screening, where you can have your employees be 6 feet away outside the door, and have a manager stand inside the threshold and ask the questions, and have ask the questions about the symptoms, and also have a thermometer where the employee out, by the employee, so the employee takes a temperature, and then you can confirm, they can confirm verbally whether, that their temperature is 100.4, I think, degrees, or lower, or less than 100 degrees. That way, if you don't have to deal with your screener or your person manager, especially if you work on different shifts, to have a manager get geared up in full PPE gear each time to screen your employees. This is a good alternative that will, I think, lessen the burden on employers who are trying to comply with these new regulations and guidances. All right, so safety policy, you also want to include, cover what you're doing to keep a safe and sanitary work environment. What kind of increased, or what types of routine cleaning efforts and requirements are you as an employer implementing? And then also include reporting procedures for safety issue concerns and COVID-19 reporting. Make it clear that any issues should be reported, and that, obviously the symptoms should be reported, and to whom the employee can report, and also include what you as an employer plan to do if if one of your employees tests positive, in terms of who, you'll need information about who the employee has been around and what work locations, if applicable, and make sure that you note that the name of the employee who has tested positive will not be disclosed because of HIPAA issues. But all of this helps because there is some shared responsibility here. Of course, you as an employer, you want to make the work environment safe for your employees, but at the same time, you don't have 100% control over your employees all the time. So you need them as well to help. And the main thing that they can do is comply with your new safety measures, and also, of course, report any symptoms or a positive test. That way you can handle, and you can appropriately and promptly respond as necessary. This way, a safety policy, your employees know what they need to do, and you can have them go ahead and have them acknowledge the policy if you'd like, or post it somewhere where you have most of your other employee notices. And most importantly, of course, you want to train your managers, and also your employees too. You don't want to just kind of throw a piece of paper at them and say, read this sign. I think this is important. This new normal is going to be important enough to that you'll want to sit with your employees and talk through and make sure that they understand what is being required of them, and that what you are doing to keep them safe as possible.
So the next issue, at this time, it seems almost inevitable that there may be a time that comes while everybody's reopening that an employee either starts experiencing COVID-19 symptoms and may have to miss work. And so when you have an employee who does that, what should be required of an employee who starts exhibiting those symptoms, what should be required of them to be able to return to work? And so the specific question here is, should employers require a negative COVID-19 test for employees to return to work? The answer may surprise you, but we say no. The CDC has confirmed that the false negatives are possible. That's not only with regular COVID-19 tests, but also with the antibody tests as well. And so the CDC itself recommends that someone who is symptomatic consult their healthcare provider about what they should do. And more than likely, if an employee, so what we think should happen is require a doctor's release. because if an employee consults with their healthcare provider, they're more than likely going to go through that quarantine period. And also, they may have to go take a test, but if testing isn't available, it's just really important that they consult with their healthcare provider and go through that home isolation quarantine period to make sure that they've the symptoms or COVID-19 has run its course. The short answer is no. More than likely, a doctor's release would be would be something that would be a better requirement for an employee to return to work. And another thing that employers may have to consider at this time is whether they have employees go on business trips. Hopefully this isn't a big issue at this time with society opening up in phases and in steps and hopefully nobody's doing a lot of traveling at this time. But we have to, when you are deciding upon whether an employee goes on a business trip or not, one thing that you have to consider is stay-at-home orders. I know at this time, most of them have either expired or close to expiring in all areas of the U.S. But that's something that you have to keep in mind, and whether it may impact or restrict travel for that particular business trip. Another thing is just consider whether it's even necessary. The CDC has kind of recommended that if you can, to consider canceling, adjusting, or postponing large work-related meetings or gatherings. Some industries as a whole have turned to virtual conferences. For instance, the Arkansas Bar Association's yearly conference is virtual this year. Other conferences have turned to virtual instead of allowing in-person meetings. And another thing that you have to consider is the Americans with Discrimination Act. So I'll kind of expand on this in the next slide, but it's really important that if you have an employee who may have an underlying health condition that puts them in that high-risk population for complications if they are to contract COVID-19, if they request not to travel, that may be a reasonable accommodation request under the ADA. And that's something that you have to keep in mind because it would trigger the need for an employer to engage in the interactive process to see how they can make sure that an employee is reasonably accommodated. And so when that happens, some things that you may want to keep in mind are teleconferencing or video conferencing as well that may be sufficient instead of having an employee go on an actual business trip. So like I was saying earlier, the ADA, out of all the compliance issues that we talk about, all of them are important, but the ADA is very thorough in its requirements and is really important at this time to make sure that you are addressing it carefully and documenting what you're doing when doing so. And so under the ADA, there may be the need to possibly accommodate those with underlying conditions and disabilities, especially if they have those underlying conditions that put them in the high-risk population of the increase of complications from COVID-19. And so some simple accommodations may be telework, a leave of absence, whether paid or unpaid, or a flexible schedule. Like Jane was stating earlier, maybe if you're staggering your shifts, it could help decrease the number of employees in the workplace at one time. And the CDC has identified a number of medical conditions, chronic lung disease, serious heart conditions, diabetes, obesity. If these conditions are not well maintained, it could very well mean that if someone is to contract COVID-19 and they have one of those, then there's increase in the potential for complications. So you want to make sure that if these employees are asking for accommodation, that you're working with them on those. And I just read an article a week or two ago where in New York, one of the hotspots of COVID-19, there have been a number of disability accommodation complaints because employers are not they have not been approaching the ADA carefully when trying to work with employees on doing reasonable accommodations. Some of them more minor accommodations may be extra protective equipment. So maybe in addition to a mask, may have one of those the visors or glove extra maybe gloves in addition to a mask. In addition to just health conditions, you have to think of your employees who may have mental in physical health conditions. You may have to think about employees who have mental health conditions as well. So you may have an employee who may suffer from PTSD and may not be able to wear a mask. That may be a different type of accommodation you have to make. Maybe getting that employee to a more socially distanced and isolated place in the workplace for them to be able to continue working. And I think, yeah.
All right. So what other compliance issues should an employer be thinking about right now? One that may be kind of may not be on employers' minds as much because it's so new. The Families First Coronavirus Protection Act, or the FFCRA, was just passed and enacted in March of this year. It was obviously in response to the COVID-19 pandemic. And it requires employers with fewer than 500 employees to provide employees with certain leave benefits for specified reasons related to COVID-19. The Act contains two distinct provisions: the Emergency Paid Sick Leave Act and the Emergency Family and Medical Leave Expansion Act. It applies to leave taken between April 1st of this year through December 31st of this year. A couple of just things to note. The Act does include exclusions for healthcare provider and emergency responders, but it's up to the employer if the employer opts to apply those exclusions. And also, covered employers must post the FFCRA notice, which has been published by the U.S. Department of Labor, and it's on the Department of Labor's website. This notice must be posted in a conspicuous place, a break room or wherever if you've got a clock in, if you've got a time clock. Because your employees are working remotely, in that case, then the Department of Labor has said that the notice then should be emailed or directly mailed to those employees, to your employees, or even, if you've got an intranet, you can post it on this type of employee information website. All right, so let's talk first about the Emergency Paid Sick Leave Act of the FFCRA. This provision, this portion of the FFCRA provides up to 2 weeks or 80 hours of emergency paid sick leave at the employee's regular rate of pay, up to a max of $511 a day. If the employee is subject to a quarantine or isolation order, has been advised by a healthcare provider to self-quarantine, or is experiencing symptoms of COVID-19 as in the process of seeking a medical diagnosis. Also under the EPSL you can get up to 2 weeks, or an employee is entitled to up to 2 weeks of emergency paid sick leave at the employee's two-thirds of the employee's regular rate of pay, up to $200 a day max. If the employee is caring for an individual that's subject to a quarantine or isolation order, or has been advised by a healthcare provider to self-quarantine, or to care for the employee's child whose school is closed or childcare provider is unavailable for reasons related to COVID-19 and no other suitable person is available to care for the child, or if the employee is experiencing a substantially similar condition. This is not, according to the U.S. Department of Labor, there are no substantially similar conditions known yet. So it's unclear for now what that really means. But I'm sure the Department of Labor will update its guidance if there is a substantially similar condition identified. The Emergency Family and Medical Leave Expansion Act portion of the FFCRA, it amends and expands the existing FMLA. So the expanded FMLA, it covers employers with fewer than 50 employees, meaning it applies to employers that are not covered under the regular FMLA, because the regular FMLA threshold is 50 employees. Regular FMLA only applies to employers with 50 or more employees. There is a possible exemption that is available, and then the other way that the expanded FMLA has amended the regular FMLA is that it covers that employees need only 30 calendar days of employment, as opposed to, the regular FMLA has the year requirement, and then a couple other factors to consider. But under the expanded FMLA, it's just, all you're looking at is whether the employee has 30 calendar days of employment as of the day that he or she requests leave under the expanded FMLA Act. All right, so under the expanded FMLA, an eligible employee is entitled to up to 12 weeks of job protected leave to care for an employee's child whose school is closed or whose child care provider is unavailable for reasons related to COVID-19 and no other suitable person is available to care for the child. Of the 12 weeks, the first 2 weeks are unpaid, but an employee can use emergency paid sick leave or any available PTO or vacation time that he or she has accrued. And then the subsequent 10 weeks are paid at the employees paid at 2/3 the employee's regular rate, up to $200 a day max. The job restoration requirement does not apply to employees with 25 employees, with fewer than 25 employees under specific circumstances. There's some requirements in terms of, the position no longer exists, and then as the employer, there are certain requirements that an employer has to meet in order to qualify for this exclusion, the job restoration exclusion. One thing that's worth noting, given the time of year right now, is summer vacation. The Department of Labor has said that both the Emergency Paid Sick Leave Act and the expanded FMLA provisions are not available if a child's school or child care provider is closed for summer vacation or any other reason not related to COVID-19. But keep in mind that the employee may be able to take leave if his or her child care provider during the summer, for instance, a camp or other daycare program in which the employee is enrolled. If that program or provider is closed or unavailable for COVID-19 related reasons, then the employee could be eligible for expanded FMLA. One thing worth noting, given that as a result of the pandemic that many employers, may have faced or be facing a decline in business volume, and even if temporary, employers may be having to make decisions on cutting employee hours or wages. Just be sure to abide by relevant wage and hour laws in making those decisions. Most notably, when you're dealing with hourly non-exempt employees, of course, you want to make sure that their hourly rate does not dip below the minimum wage requirement. And then when dealing with salaried exempt employees, there are very specific regulations as to how and when, under what circumstances you can deduct from their salary. So just, be aware that all these other laws apply, and especially be careful with the wage and hour laws, since that's a pretty, in terms of litigation, wage and hour law violations are, it's still going strong. So you want to make sure that you're careful about how you reduce hours and wages if you are in need to do so.
I'll try to run through the rest of these. I think we may be going a little bit over on time, so I'll try to rest through these so we can get to the questions. So one of the other laws that employers need to be aware of is Title VII. Certain types of discrimination and harassment may increase during the COVID-19 outbreak, particularly in the Asian American community. The EEOC itself has already released a statement urging employers to be more vigilant and monitoring their workplaces to make sure that this discrimination and harassment doesn't occur. Mishandling claims or ignoring the discrimination and harassment could lead to retaliation, wrongful termination by way of constructive discharge. Also, there could be discrimination claims related to what Jane was just talking about, wage and hour decisions. So if you're making pay cuts individually as opposed to maybe across the board or for a particular set of employees, that could very well lead to a Title VII complaint from anybody who may be in a protected class under Title VII. Then there's the Age Discrimination and Employment Act and the Pregnancy Discrimination Act. So basically making decisions based solely on the people in these protected classes, an employee who's pregnant or an employee who may be older than 40, deciding on maybe, and Jane touched on this at the beginning of the presentation, when you're doing callbacks, deciding not to bring your older employees back, or maybe employees who may be pregnant based solely on that characteristic, could lead to a complaint under both the ADEA or the PDA. So those are some things that you have to keep in mind with making those decisions.
All right, we do have a few minutes. We can open it up for questions. If you do have a question, go ahead and throw it in the chat box, or you can unmute yourself and go ahead and ask it live. And I'm also gonna be cognizant of Facebook Live and check over there too. I'm gonna go ahead and mute myself. So if there's any questions, use that chat box or ask your question live. No questions. Y'all answered all the questions. That's how good you guys are. There are absolutely no questions. Y'all covered all the topics.
But I just have to practice my presentation, my operation skills. Sorry, Daveante.
Let's see, Mimi, you got something?
I just wanted to say what a great information, and you guys were so comprehensive, and doing the Q&A, you answered a lot of our questions.
I've got something, Ashley. And I don't know that this is a question, but I've had two guys that are friends of mine that have people that own businesses. One of them's a yard service guy, and I forgot what the other one actually was referring to, but said they could not get people to come back to work because they were making enough money through the unemployment stuff that they just didn't want to come back to work. Have you guys run into that? And if so, what do you do about it?
And this might be because I was not doing great on the beginning of the presentation, and so my slide showing was a little bit bad. But this is Daveante covered this. Is that I think the biggest thing is you can if those employers report to the Department of Workforce Services, that an employee that someone has refused an offer to return to work, then at some point their benefits should be cut off, because that is a rejection of an offer to return to work, and that ultimately would disqualify them from benefits. Daveante, please, this is your area, so.
Yeah, I mean, that's correct. Just make sure that they communicate, like Jane said, to the Division of Workforce Services, that they've made the offer. And if they're refusing the offer, not for a valid reason related to COVID-19, like you said, if the reason is just they're making more money, then they should be ineligible for benefits. Yeah,
that's the story as it gets told. Yeah, whether that's true or not, I really don't know that. But if it is true, that's a problem. Yeah, right. And I mean, and like I said, the yard guy is going out of business, and he's been in business for over 30 years. And this guy out here in Little Rock that I've known for a long time. And, it may be directly related to that, or it may be that he just can't find people to do the work at what he wants to pay him. I mean, it may be a completely different circumstance than what he's saying it is, but that's what he's saying it is.
Yeah, so that is another thing. It has to be a suitable offer. So basically, I'm trying to think of a good example. If you have like an engineer or something, and you try to bring him back as like a janitor, it may not be a suitable offer of employment. Or if you decrease pay so much, it may not be a suitable offer. But you also have to keep in mind that somebody who's working part-time and not making 140% of the weekly benefit amount would still be eligible for unemployment. So he may have to kind of communicate that to the employee, like, hey, we're not going to bring you back on full time and your pay may be cut, but you can still work and still be eligible for the benefits as well. So that's something that you can talk to them.
Okay. Thanks. And you need to go change the battery in your smoke detector.
Yeah, I should have.
I told him that from the beginning of the pandemic.
Sorry about that, everybody.
Safety first, everyone.
Well, it's just one of many things that happens with the fact that everybody's working from home, Right.
I love that. And that was a great question. And any of those questions, like I said, the way that they laid out their slides today has a lot of the questions that you may have thought to ask later on. So like we mentioned before, this is recorded and on Facebook Live, so you can always refer back to it for questions. So be sure to do that. And we are out of time. We've hit that 12:30 mark. So I do want to thank Jane and Daveante for this session. Any of our participants that tuned in via Zoom, as well as Facebook, and as always, our awesome sponsors, Wright Lindsey Jennings, Frost, and the Little Rock Regional Chamber. We do have several more programs coming up in the month of June and thereafter, so be sure to like us on Facebook, check out our website, and sign up for our newsletter so you can keep up with the latest and greatest from us, as well as the programs that we have going on. With that, thank you, everybody, and we hope to see you again soon.